Ever heard of a surrogate court? Have you ever wondered if a surrogate court handles breach of contract? If you're on my channel and you're looking for a surrogate court, it may not be exactly what you think it is, but some things still apply. Let's jump in and figure it out. What's up? My name is Corlandos Scott, and I'm a surrogacy attorney based in Los Angeles. And I, unlike typical surrogacy courts in some states, help people have babies. Yeah, that kind of surrogacy. So if you're growing your family through surrogacy, egg donation, sperm donation, any kind of assisted reproductive technology, I'm the type of attorney that you'd work with to help you handle the legal side of things. And in this video, we're going to cover what is breach of contract and what it means in surrogacy. We're going to look at what court handles a breach of contract in this context, and we'll also talk about how breach is addressed in surrogacy. So what is a breach of contract? It's just a fancy legal term. It means one party in a binding agreement failed to deliver or perform the obligations according to the terms of that binding agreement. I like to say it like this. A breach means you did something you weren't supposed to do, or you didn't do something you were supposed to do. One of the frustrating things about breach of contract is there's no hard and fast rules. Essentially, most people will say that a breach is any deviation from your promises in the agreement. So you could look at the agreement and the facts of your situation and say, I think that other person is in breach. But just because you claim that there's a breach or you allege that there's a breach doesn't mean that there's necessarily a breach. There needs to be some uninterested, unbiased third party who takes the terms of the agreement and compares it against the facts and determines whether there is an actual breach. And to do that, you got to bring a case. Yeah, so you need somebody to hear your argument as to why there's a breach of contract. So you feel like somebody's breached the contract with you and you want to make them pay. You want to hold them accountable? Well, like I said, you have to initiate a claim. But where do you do that? Well, first, let's talk about what courts can hear claims and arguments and all that kind of stuff. This is going to be like a mini little law school lesson. So I'll basically just give you a degree after this episode. So for a court to hear your breach of contract claim, they must first have the authority to hear the breach of contract claim. And why do I talk about the question of authority? Because courts have different jurisdictions or different purviews, different areas where they're allowed to be the deciders. So their authority to hear or entertain a case depends upon what type of court they are. It's basically a system that allows them to filter out cases and limits their authority. So every court can't hear every case. So there's two types of authority to hear cases or jurisdiction. There's jurisdiction over the legal issue, or there's jurisdiction over the person involved in the matter. If we're talking about jurisdiction over the legal issue, then before a court can entertain or hear your case, the court needs to have the authority to do that. So for instance, an appellate court can't entertain a case that's being brought for the first time because a court that hears appeals means that a lower court has already heard it. That's an example. So for instance, another example would be tax courts only entertain federal tax cases. You can't file a petition to establish parentage in a tax court. Just doesn't work like that. Then I said courts can have jurisdiction over the person. So if one of the parties is from outside the state where the case is brought, and that party raises that fact as a defense, then the court may not have jurisdiction or authority over that person or that case. Let's say you're from Louisiana and a matter is being brought in Connecticut. You may say, look, this court doesn't have jurisdiction over me. I'm not in that state, and I'm not going to visit that state for them to get jurisdiction over me. Now, I know the title of the video talked about surrogate courts and breaches of contract, but let's be very clear. I want to clarify something. The phrase surrogate court is not a court handling cases filed by surrogates or intended parents regarding a surrogacy agreement. So what is a surrogate court? And what is its jurisdiction? Well, a surrogate court really has jurisdiction over ownership disputes between living persons and decedents, or people who have died. So some know that as a probate court. This is the type of court in some states that administers wills and estates and handles guardianships and trusts and things like that. The idea is they're playing on the actual definition of the word surrogate, somebody who does something in the stead of someone else. So if a person has died, if they're deceased, they can no longer administer their estate. So the court steps in as a surrogate for the deceased person. So that's what many people are referring to when they're talking about a surrogate court. But I think it's a good time for us to address surrogates in a assisted reproduction arrangement and breaches of contract. So let's talk about breaches of contract in a surrogacy arrangement. Hey, but before I do me a quick favor. Just go click the like button. Just real quick. It's not even going to take a minute. It's nothing. It's no big deal. Just knock it out. Yeah, see? Easy. So yeah, let's get back to it. So what does it mean to breach a surrogacy agreement? Well, surrogates can breach a surrogacy agreement. When a surrogate agrees to, for instance, follow the medical instructions and she fails to follow medical instructions, that's a breach. When a surrogate agrees to inform the parents before moving out of state or traveling out of state and she fails to do so, that would be a breach of the agreement. Here's another example. When a surrogate agrees to terminate the pregnancy at the doctor's recommendation to the parents because the baby has a medical issue that the parents have asked the surrogate and she's agreed to terminate under, and she doesn't do it, that would be a breach of agreement. If you're curious about how abortion termination reduction works, go back and watch my video on reduction of a pregnancy and watch the other on can a surrogate abort a pregnancy. Last but not least, I've never seen this happen in any of my cases, any of my colleagues' cases, but I have heard that it has happened before. So another breach would be when the surrogate refuses to release custody of the child or surrender the child to the intended parents after delivery. That would definitely be a breach of contract. But surrogates aren't the only party to a surrogacy contract. There has to be another side, right? The intended parents. Well, intended parents can break their promises or fail to live up to the terms of the contract too. And when intended parents fail to fund the trust account or the escrow account to answer for the medical expenses, that's a breach of contract. When intended parents fail to make the proper payments or reimburse the surrogate for the agreed upon surrogacy-related expenses, that's a breach of contract. If the intended parents fail to take custody of the child after delivery, that is a breach of contract. You would be surprised, but I hear more cases where the intended parents abandon the baby than I've ever heard of surrogates wanting to keep the baby. So that would also be a breach of contract. If the parents violate the surrogate's confidentiality and privacy, again, that would be a breach of contract. So going back to the idea of surrogacy courts, you may be wondering, well, what courts do surrogacy-related cases go to if they don't go to surrogacy courts? Well, again, we realize they're using surrogacy in a different context. But a surrogacy-related case with regards to assisted reproduction simply goes to the court in the state that has jurisdiction over that surrogacy agreement. So for instance, if a surrogacy arrangement happened in Los Angeles based on California law and it was drafted with regard to being heard and under the jurisdiction of the County of Los Angeles, it would simply go to Los Angeles Superior Court in the proper department that handles those cases. So essentially, any court that has the authority to hear your case, the legal parentage or custody or breach, one of the places to look for a clue as to where a breach of contract should be filed in your particular case, it would be included in the terms and conditions of the surrogacy agreement. Oftentimes, there will be a choice of law section and a jurisdiction section in your surrogacy contract. And it'll tell you what court each party is submitting to with regards to jurisdiction and, of course, choice of law. So that's going to be a great place for you to go check to find out where to bring a breach of contract claim in a surrogacy arrangement that you're in. But now's a good time to discuss how we handle breach of contract claims in a surrogacy agreement. Because this isn't any old agreement, right? Once a surrogate is pregnant, she's kind of pregnant, and there's really no turning back until she delivers. So surrogacy is a bit different than other contractual relationships because it's not just like, I hired someone to mow my lawn and I get angry with them and it's all bets are off, stop mowing my lawn. Well, I can't say all bets are off, stop carrying my baby. It's not necessarily safe. So there's a nuance and there is a certain finesse that needs to be applied to surrogacy arrangements, even with regards to breach of contract claims. So when there's a possible breach of contract in a surrogacy agreement, the parties just don't steam head first and file a case in court. First, we take steps to assess the potential breach or material breach, and it's really handled in more of a gradual nature so as to make a determination and not jump to conclusions. First thing we need to do is determine if there's a breach or if there's a likely breach. Now, some things are very easy to determine. Let's say that the surrogate was supposed to have a doctor's appointment and the surrogate didn't show up at the doctor's appointment. Well, that's very easy to find out. We can just simply check the records at the doctor's office and find out, did she show up? If she didn't, that's a breach of contract. But again, it's not time to run to the court and file a breach of contract claim. The first thing we do after there is a likely breach or a seriously alleged breach is we provide notice to the breaching party. So after you discover the breach, put the other party on notice that, hey, I think you violated the contract. And again, you wouldn't want to do this directly. If at all possible, you want to work through your professionals. That's why you pay them. So you want to reach out to your attorney to contact her attorney or the parent's attorney or vice versa, however the breach is flowing, or even get the agency involved if you have an agency helping. But you want to put the people on notice that they breached. The next thing that you should do is give the breaching party the opportunity to cure the breach or fix it. That's what I mean by cure. So essentially, you give them the opportunity to make it right. And if it's something as simple as missing a doctor's appointment, then for sure you can reschedule the appointment and hopefully for a very close time and get it knocked out. And that way you've cured or you fixed the breach. If there's a breach and it can't be cured in a timely fashion, you would want to take a step prior to initiating court proceedings. And that step may be mediation. So the agency and the attorneys would first try to mediate or settle the misunderstanding, or maybe you take it to formal mediation with a mediation company. If efforts at mediating the issue fail, you can also bring in a mental health professional to talk through it if it's only issues that are related to relationship or relational issues. If talking to the mental health professional doesn't work, if mediation doesn't work, then you can actually go to arbitration. And that's when the dispute is brought before an arbitration board or an arbitration court, and you have a hearing that's very, very similar to a court hearing and actually is held by attorneys or retired judges, and it's private in nature. And really a lot of intended parents and surrogates, they rather go the arbitration route than court because, again, it is private. Once you file something in court, it's public record for the most part, unless it involves a minor. And some courts do view surrogacy arrangements as court proceedings that involve minors, and they will seal the records so that it's not available to the public. But that's not a guarantee. So that's why most parties will prefer to have an arbitration, because they get the same level of a court proceeding, but it's a private resolution to the issues. So in an arbitration, the arbitrator will hear the case and they will make a binding decision on the matter, just like if it was a court. And then last but not least, if all those things fail, you can always take your matter to a court of competent jurisdiction, meaning a court that has the jurisdiction to hear the case. If you're in a surrogacy arrangement and you feel like the other party has breached the arrangement, my first advice is reach out to them through your representatives. But if you still can't find any satisfaction and you need some help, reach out to me. I may or may not be able to help you, but I may also be able to point you in the direction of someone who can help you if you're in a different state or if I just can't take the case or something like that. So if that's you and you want some help or you want to talk to somebody about your situation, just click the link below and you'll be taken to a chat with me. And we can chat. We can talk about it.